Hello, my name's Carl van der Merwe. I'm with EB-5 Coast to Coast, and I have the great pleasure of having Kripa Upadhyay with us today, a very experienced immigration attorney based in Seattle with Buchalter. And she's going to discuss the very important topic of documenting your source and path of funds. Kripa, thanks for joining us today. It's wonderful having you on the webinar. Um, if you wouldn't mind just introducing yourself and then take it from there.
Of course, thank you for having me. As Carl said, my name is Kripa Upadhyay. I am an immigration attorney with Buchalter at the Seattle office. We do have offices pretty much all across the US, but the immigration team is essentially based in Seattle with also some of my colleagues in Portland, Oregon. My personal experience in EB-5 goes back several years. I currently serve on the AILA, which is the American Immigration Lawyers Association National Chapters EB-5 committee. So that is the committee that basically monitors trends and adjudications with respect to EB-5s that are filed within the United States or outside as a whole. We often liaise with USCIS, so some of the information I'm going to be sharing with you has to do with recent trends in terms of adjudication that we're seeing out of the consulate, out of the consulates and also out of USCIS. So without further ado, let's get started. Right now, some of you, I know I sometimes still get questions about it was 500, why are we now at 800? That's because the program changed. So under the Reform and Integrity Act, if you are now filing your EB-5 with a project that is either rural or high unemployment or infrastructure, essentially in what is called a targeted employment area, the minimum that you have to invest is 800,000. Anything outside of that is a minimum investment of 1.05 per applicant. If you are investing in a rural or TEA, you are likely going to come closer to 930, 950, somewhere there, depending on the regional center that you select to work with. And that's because most regional centers will charge you what's called an administrative fee. And that currently depends on the project, but average market rates are anywhere between 30 to 90,000 per project. And then attorney fees also significantly different depending on who you choose to work with. That can go anywhere from 20 to 35,000 for applications going into regional centers. For people that are electing to file standalone or direct investments, the upfront cost is going to be significantly higher. But those are your options. Right. Source and path of funds. This is the most crucial part of your EB-5 application. USCIS holds EB-5 applicants to what they call a preponderance of the evidence standard, which basically means that applicants are required to provide as much documentation as they can to show that their funds were legitimately earned, so legally sourced, and also legitimately transferred. The transfer or the path of funds is very, very important because certain countries have very strict currency restrictions. And so USCIS wants to make sure that the manner in which you transferred the funds was legal, right? And we'll talk a little bit about specific issues with respect to India and China, but your source of funds and your path of funds, both of them have to be fully documented. And failure to do that will cause denials on the I-526 portion. And there's your new trend alert. We are seeing denials now at the I-829 stage. So for those of you familiar with the EB-5 process, the I-526 is your first application. That is the one where you essentially provide all of the documentation about when and how the money was earned. USCIS approves that application, and you become a lawful permanent resident for 2 years. Typically, 90 days before your 2 years expires, we file the secondary application, which is your I-829. What we are seeing increasingly at USCIS, unfortunately, is officers going back to the previously approved I-526 and saying this should never have been approved to begin with. Right? There were significant gaps. There wasn't enough information. Because the I-526 should not have been approved, we are now going to deny the I-829 almost 2, 3, sometimes 5 years after the first decision was made. So it's even more crucial now that you ensure that your source of funds and your path of funds are fully documented.
That's
Right.
a very unfortunate turn of events because, as you point out, it's 2, 3 years or more down the road.
Mhm.
And in the past, they never would do that, would they? They wouldn't re-review the 5 to 6 at the 8 to 9 stage. It's
No,
that's not something that they were doing in the past, clearly.
no, this is a new trend. And what
Yeah.
makes it so difficult, as I'm sure you're alluding to, is the inability to go back and get documents that are now 7, 8 years later, right?
Wow.
Because some of those documents may no longer exist. They may have been, legitimately shredded, done away with. People no longer have contacts in those countries anymore to help them go back and find these documents. So it really is putting applicants in a very, very difficult position. But this is something that we have noticed. It is a new trend. There are conversations afoot about how to address this with the service. Some of this may very well end up in lawsuits against USCIS. There are attorneys working on that front already, but it's something I want to make sure to highlight so people understand just the absolute imperative of making sure that you have all of your documents in place so you can avoid the situation to the extent that you can, right? Now, with respect to the kinds of things that you can use for your funds, I mean, there's really no limit, right? As long as it's legal and you can document that it's legal, you can use a variety of them. You can use a combination, you can use a solo source. The most common one, obviously, is going to be income from employment. And in order to show that, we basically need to be able to document your salary, and salary includes your bonuses or any additional compensation that you may receive. So, again, if you are in a country that has a tax payment system, then that would mean documenting your employment, documenting your salary deposits in your bank accounts every month, and then also tax returns for the last 5 to 7 years, depending on your annual income. If you are from a non-tax regime country, then that means providing 5 to 7 years worth of bank statements for every single month to show all of the salary deposits. And then typically, as I know I do as an attorney, include information about their not being tax system in the country of residence or in the country of origin. But we need to be able to show the earned income or the earning of the salary and then also the accumulation of it, which is why we ask for the bank statements, is to be able to show that all of the funds were accumulated prior to the investment. Anything that you acquired because of your salary, so an investment portfolio, stocks, bonds, FDs, CDs, anything like that, all of that tied to income needs to be documented going back to your income. You can also include employee stock options, restricted stock options. Again, that would go back to income. So potentially, or employment, so potentially a agreement with your employer, which says what your RSUs are, what the restrictions are, what the vesting schedule is. All of that needs to be documented. Business income, the one thing I want to highlight here again is the very first point. You cannot transfer funds directly from a business account, even if you own 100% of it. I find myself having this conversation with clients a lot. They don't understand if they own 100% of the business, why can't I just write a check out from the business account? Because the business account, according to USCIS, is not a personal account, right? So even if you own 100% of the business, you can take funds from the business account, either as income or as a distribution or a profit that you are legitimately allowed to take. But what USCIS expects is that you have then followed through with the law and either paid taxes if you were required to, or if you're not required to pay taxes, then great, but at least show that you took the funds out of the business account and that the individual invested the funds, not that the business invested the funds. And then again, documentation to show that you actually own the business or whatever the degree of ownership is in the business. Bank statements, very, very important, whether you are using, um, your income or whether you're using something to show that you had fixed deposits or certificate of deposits. We need to be able to document, in the case of CDs and FDs, when was that purchased? Where did the money come from to buy, to invest in CDs or FDs? And then if either one of those were vested and you received the funds and those funds are being used for the EB-5, then we need to show that money coming back into your account. That again goes to accumulation of the funds. So we have to be able to document every single link in that chain from the time that the money was earned to the time that it was essentially wired or deposited into the funds for the regional center. HELOC and sale of real estate. So I'm going to deal with the HELOC one first. For those of you in the US, pretty simple, right? We just need to be able to document where did the money come from to purchase the property in the first place? What was the purchase price at the time that it was acquired? Documentation from the bank with respect to your HELOC. What are the terms with respect to repayment of the loan? And that should be it. For anybody that is contemplating taking a bank loan from outside of the US and then using that for purposes of the EB-5, I would caution you against doing that. With respect to India and China in particular, most banks in India and China have language in their loan documents. India specifically has language in their loan documents which says you cannot expatriate bank loans for speculative foreign investments, and EB-5 counts as a speculative foreign investment. And that's in the documentation for the bank, so you cannot do that. Inherited property, again, necessary to establish relationship between the person that you are inheriting from and you. So ideally, if that's a parent, birth certificates, if there's a will, and that was the basis of the inheritance, then a copy of the will and last statement. Typically, there will be something from estate court in countries where you have to go through some sort of an estate procedure. All of those documents would be required. Gifted properties absolutely can use, but again, you need to have a gift deed for the person that gave you the property. And then if the property is gifted to you, then where did the money come from to buy that property, right? So then we need to go back to document that entire chain.
Kripa, I'm sorry to
Yeah.
interject here, but I have a quick question.
Yes.
When you say we have to go back to documenting where the money came to buy that property, like, is there a statute like of limitation in terms of years, like how long ago the property was purchased, or it doesn't matter? Like, let's say my dad bought a property 40 years ago. Do we still have to do source of funds on that?
As far back as you can go, yes. And typically at that point, I will get a country expert in the country where the property is cited to say legally records do not go back that far,
Oh,
right? So most countries have a different statute with respect to how long courts or attorneys are required to hold on to documents.
uh-huh.
If it's beyond that time, then they're just not available. And so then you have to try to do the best you can to go as far back as you can to document it. But it's not enough to say, my grandfather gave me a gift. USCIS is going to want to know where did grandfather get money from to purchase the property in order to give you the gift, because it goes back to the source of funds needing to be clean.
Got you. But there is a way, like, for example, if it's a really old property and there is just no way to obtain that documentation, because let's say years ago people didn't even work under W-2s or under any type of system that kind of kept track of them. There is a way where you can get a country expert to just say, this is how things were done at that time. This information is no longer available, and that will be okay.
Yes. So for example, I filed one recently for somebody that is currently living in Prague, but her property was property that she inherited from her grandfather before the country was renamed, right? So it was when the country was
Right.
Czechoslovakia. And so we literally had to go as far back as we could to document who her grandfather was, where he got the funds from, get whatever documents we could from court for the testate, for the will portion
Right.
of the funds, and then document all of that.
Got it. Okay. Very
Let's see. So, special considerations for Indian investors in particular. So, in India, you have this thing called the Hindu undivided family or Huff property, and this typically comes in for joint property, as we call it, right? So, property that stays within the family. So, if it falls under the construct of Huff, you have to explain to USCIS how you acquired the portion of the property that you did and whether your other aunts, uncles, siblings assigned their shares to you and whether you paid them or what the process was for that. So I have again an example. I just got an approval notice yesterday for her case. Her source of funds were funds that were related to Huff. And so we basically had to get letters from two uncles and an aunt talking about what their respective shares were under Huff, and then how much they had gifted to the niece, and then gift deeds from each of them to the niece, then document the funds going from their accounts to her account, and then from her account to the regional center account. So if it is Huff, then we have to have court documents that again show that it was in line with any issues having to do with Huff properties in India and how the court administration ended up working through. Bank loans in India, I think we already talked about this. Be very careful because there is language restricting the expatriation of money outside of the country. And this has to do with a whole slew of Indian billionaires that had taken significant amounts of money from the bank and absconded and went away in various circumstances. And so this is something that's come up for those of you that are from India, post Vijay Mallya, post Nirav Modi, post those cases.
wow.
Real estate sales, much of South Asia and Asia in general, there is a system of doing the 50-50 black and white, right? So there's a circle rate and a tax rate. The problem with these arrangements in the EB-5 consideration is there's no way for you to be able to document the black portion because you took that in cash. You still have to be able to document where that money came from. I have an explanation as to where that money came from. So if your tax rate is 500,000, then you can only claim 500,000 for your EB-5. They're going to have to use a completely different documented source of funds for the remainder, right? So that's why I have this not allowed because you cannot do a circle rate versus tax rate for purposes of EB-5. This is,
Kripa, if
yes,
if I may just ask you one quick question about the
yeah.
previous so you when you talk about bank loans, you're
Mhm.
saying that in India, for a fact that the country has prohibited that type of practice. But if an investor is from any other country and they, want to get a loan against their property, that's acceptable as per USCIS. Is that correct?
Yeah, perfectly acceptable as long as the bank does not have any restrictions with that loan being expatriated from their country
Uh-huh.
and being used for a different purpose. So, for example, if you're taking a bank loan saying, you're taking a loan for a HELOC, then make sure that the language of the loan document that you're signing or your loan contract with the bank does not restrict you from number one, being able to use that for anything other than home renovation or whatever it is that you claimed you were taking the money for, and that there's no restriction against expatriation of those funds out of the country.
Got you. And USCIS would know, right? So, like, if someone wanted to just say, you know what, I know this law exists, but how is USCIS going to find out? I'm going to do it anyway. USCIS would know. Oh,
Yes, because we have to include, well, you have to include the loan document in your
beautiful.
EB-5
Okay,
packet,
understood.
right? So they will find out.
Got you.
Right now, this one, I don't know if you guys have seen this, Carl. I don't know if you all have encountered this, but this is becoming very, very popular, particularly amongst those that are in the US on H-1B,
Mhm.
using 401k and self-directed IRAs as a source of funds. This is wildly popular right now. I think it's something that we've seen maybe within the last year. This wasn't something that we encountered prior to that. So The short of it is that it is legal. USCIS has approved applications now, multiple applications, where 401ks or self-directed IRAs are the source. How you go about doing it, though, is very, very different, and you have to be very careful. You have to have clear and comprehensive documentation demonstrating the source of the 401k and the rollover process. You may also need to include your statements for your 401k, documentation of the rollover, and then also, again, because EB-5's an EB-5 investment is a security offering and is governed by the SEC. You may also need to work with a specific individual that is authorized to do so. And I think most regional centers right now are working with one or two commissioners that can help with the documentation and the transfer and the rollover process for you to have all of the documentation that you need. But this is a still emerging part of the source of funds that we are seeing in cases. So be very careful about how you go about doing this. Again, obviously outside of the, using this for EB-5, understand the risks involved in terms of using your 401k to fund your EB-5 investment. But if your question is, can I do this? Yes, absolutely. I know there are a few attorneys that have done this repeatedly and successfully in the recent past few months. So this is absolutely something you can use. We're just very, very careful about which clients we use this for, and the documentation has to be very precise.
Creeper, I'm glad you brought this up actually, because this is something we've started coming across as well. So we've started, we're in the process of onboarding our projects, two projects that we have through a custodian that accepts self-directed IRAs. So we'll be able to offer this service to investors as well. So I'm very glad you mentioned this and that you have some experience with this. We'd love to partner with you on that as well.
Yeah, this is very quickly, I think, replacing the RSUs and the stock options that we used to see for H1B to EB-5 conversions, right? We're
Mhm.
seeing more and more of them now using the 401k and the SDIRAs rather than RSUs because I don't know that the vesting schedule is to anybody's advantage right now at
Right.
Amazon and Microsoft's and the Metas of the world.
Yeah.
Um,
And you've had some clients that you've helped with this as well?
yeah,
Oh, excellent.
yeah, we haven't received a approval yet because we did it just earlier this year. So it's still pending. We're within the 6 months on the data filing. So we haven't received an approval on that one yet, but it's pending at USCIS. But yeah, we have done these. Right. So gifts as a source of funds, you can absolutely use gifts. You can use it for partial amount or you can use it for the full amount. The one thing I would caution is best not to take multiple gifts, right? It's fine to take a gift from an uncle or an aunt or a parent. But when you start taking gifts from your neighbor and your third cousin twice removed, or worse yet, from an employer, and in terms of the direct investment, I see this often, right? My business partner is willing to give me a gift, but the funds have to go back into the business. At that point, USCIS is going to question whether it really is a gift. You can absolutely take gifts. Now, the person giving you the gift, the giftor, is going to need to document his or her source of funds and where they got their money from. And then there will also need to be a gift deed clearly identifying that as a gift and not a loan disguised as a gift. USCIS is very serious about that distinction. They don't like it when you file an application saying it's a gift, but in reality it's a loan. So a gift is a gift for purposes of USCIS. So yes, you can use it. Again, careful as to how many people you try to solicit a gift from. Um, right. What's next? Path of funds. Okay.
Before we move to path of funds,
Yes.
but just really quickly. So, like, let's say the boss wants to give the gift or whatnot, and it's not really a gift, but it's got terms to it and whatnot. Can that be an unsecured loan?
Yes.
It can be an
So
unsecured.
anytime there is a gift that has strings attached, I would much rather that that be an unsecured loan, right?
Right.
Because USCIS now does allow unsecured loans. I would
Right.
much rather that be an unsecured loan. I practice a little more conservatively than most. So typically when there are like loan repayment terms, I try and ensure that whatever the value of the loan is, that that loan is paid off before we file the IA-29,
Hmm.
because I want to make sure my investors are fully vested, because I don't want immigration coming back and saying, you never actually fully vested. We're not giving you the IA-29, right? So
So
I try
that
to
could
make sure that
happen.
there's,
Sorry, so
yeah.
this is the first for me. I'm sorry. I'm just trying to kind of clarify because I knew that we could use unsecured loans, but so you're saying that at the IA-29 part of it, like when time comes to file that, USCIS could come back and ask, did you pay the loan? Or at
Yes.
least are you in some sort of a process of paying the loan where the
Yep.
considerable amount of payment has been made? And so that is something I did not know, to be honest with you, and that's such great information.
Yeah. So I know there's two schools of thoughts amongst attorneys, right? There's two schools of
Okay.
thought here. I'm on the more conservative side where I try to make sure that the loan is repaid in full before we file the IA-29.
Okay.
But I know that there are regional centers that have a financing option where their repayment plan extends to up to 5 years, but there's a very defined payment plan. So
Right.
I think as long as you have one of those two options, it's fine. It can't just be an open-ended pay me whenever over the next 20 years thing, right? There has to be some sort of a plan to pay.
Got you. And the plan cannot be when and if you receive the money back from the project.
No, because then you wouldn't have put your funds at risk, and you
Got
are
you.
required to put your funds at risk,
Okay.
right?
So then that would be like not a loan, it would be kind of like a gift, but it
That would be a
would be a
gift.
gift.
Yeah.
Okay. Understood. Understood. Thank you, Kripa.
Right. So, path of funds. This is what leads to, I think, 99% of RFEs right now from USCIS.
Okay.
And that's because actually, the three major groups, Vietnam, China, and India, all have some form of currency restriction and
Mhm.
remittance restrictions. And you have to be very, very careful of working within those restrictions, right? So Chinese investors, Chinese nationals, you're restricted to 50,000 renminbi per
Mhm.
year. Indian investors, there are two separate buckets for you, or two separate lines rather. Indian citizens, Indian resident, 250,000 per fiscal year. The Indian fiscal year runs from April 1 to March 31 of the following year, right? And so often what I will do, what I will have my clients do, and this is what my clients do quite a bit, is they will make 250,000 wire on March 31st, and then go back to the bank the next day, and then put in the other 250,000 that they are allowed for that one fiscal year. Um, if you are a Indian
I
citizen,
if
non-resident, you can remit up to 1 million. Now again, with the Indian nationals in particular, be very careful. Work with an attorney that has knowledge and experience with this, because the Indian system allows you to have two separate bank accounts, right? You're allowed to have your NRE and your NRO, but one can only hold foreign investments, foreign earned income. The other can hold foreign and India earned income. And which one you use is going to be subject to different versions of the FEMA and the under the liberalized remittance scheme. So you don't want to mess up with the Reserve Bank of India on those. So just be very careful how you do that. Sorry, you were saying something.
No, it's okay. I just had a really quick question when you said about, Indian residents transferring money. So 250, that equals to 500.
Yep.
The other 300,000, I've heard people say, oh, a spouse can send that, you know?
Yes.
So that's okay, right? Like, so if a
Yes.
spouse sends it, it's fine. Will
Yep.
then, since the EB-5 investment is in the name of the principal investor, does the spouse have to make a gift or anything like that?
I do. I have them do gift deeds
Okay, got you.
to the petitioning spouse. Yeah, I have them do gift deeds to the petitioning spouse, and that's the same for my Chinese investors. Right now, for the Chinese investors, obviously, we're using a lot more people.
Right.
because that's 50,000 renminbi. Now, even with the Chinese investors, I want to be careful, and I didn't put it here because it's very case specific. But that restriction does not apply to accounts in Hong Kong.
Huh?
And so if you have a banking relationship with any of the banks in Hong Kong, you should be able to remit more than the 50,000 renminbi out of Hong Kong. But again, there are restrictions there. There's a lot happening in China right now with respect to financing, particularly since we had that arrest of the Hualian chief not too long ago. They've really cracked down on investment-based migration. So just be very careful about how you're handling these issues. Currency swaps, which you see here below, is a major issue right now. Again, with respect to RFEs and denials. The issue with currency swaps is you want to make sure that the entity you are using to transfer funds is an entity that is registered in the place where you live, right? So if there is an agency that has, let's say, agents in mainland China, but the agency itself is not registered in China and is not permitted by the government to engage in FX transactions, then you cannot use them because they are not authorized to do so within China. So there are cases where, somebody was registered in Hong Kong or somebody was registered in Singapore, but they had agents within mainland China. Those cases have run into issues with USCIS. So anytime you are engaging in currency swaps, getting funds out of Vietnam, China, India, work with an attorney that has experience that can guide you on this, because again, your EB-5 is two parts. Your source of funds have to be legal. Your path of funds, which is how did the money go from where you are living to the regional center's account, that entire chain has to be legally done and documented properly.
Big, I was, and this is just like my way of thinking. I would have thought USCIS would be a bit more lenient towards, people from countries with currency restrictions because they would know, there is currency restriction. But it sounds like USCIS would just not accept anything that breaks the law, no matter, what that law is of that country and, how differently we do things here, let's say. So it sounds like it's very important that, you do things as per your country's law to be
Yes.
accepted by USCIS.
Yeah. And now this link below is an article I had written. It's 2023. Some of this is still relevant guidance, but it's an article I had written for EB-5 Investors magazine specifically about transfer of funds for Chinese investors and some of the issues we were seeing in 2023, which again still applies. This was written post arrest of the Hualian chief, and some of the aftermath of that is reflected in that article. But you're going to what you said, the thing to remember about EB-5, right? And the reason why USCIS is so particular about the source of funds and the path of funds is because unfairly, I think, personal opinion, unfairly, EB-5 has been derisively referred to as bio green card program in some quarters, right? There's this perception, including amongst some senators, that the people that are involved in investing in the EB-5 program have ill-gotten money from wherever. And I don't think they've ever been able to provide any documentation to back up that claim, right? That people that invested in EB-5 at some point were money launderers or it was illegal money or whatever, but that language has stayed. And that language you will see continues to be reflected in documentation that we're getting from USCIS even today, right? So if you get an
Wow.
RFE from USCIS on source of funds, that language says it is the applicant's responsibility to prove to us that this money was legally earned, because the assumption is always somehow this was ill-gotten money, right?
Yeah.
And so, no, USCIS is not going to give you an inch in terms of maybe they'll forgive this, maybe they'll look over this. That's not
They
going to
won't.
happen.
So they won't do that.
No.
Thanks for clarifying that.
That issue regarding currency swaps having the agency registered, was that not an issue in Vietnam a little while back? A
Yeah.
big problem with a lot of denials.
Yep. Yeah, which is why we're seeing this, like I said, right? Vietnam, India, China, three countries that have the largest volume of EB-5 cases. We're seeing the largest number of RFEs against those three because all three have currency restrictions.
Hmm. Wow.
Right? Okay, so the source of funds report, I just put this in here because I tend to drive myself crazy every time I handle these for my clients, but this is incredibly important. So again, it's really your responsibility as potential investors or as investors to do due diligence into the people that you are working with. The source of funds report is what USCIS is going to look at in terms of seeing whether you have at least made a sufficient documentation, right, of when and how the money was earned and how the money was transferred. They want things to be clearly labeled. They want specific bank account numbers, specific bank names. Um, all the documents that are not in English obviously have to be translated with certified translations included. They also not like, they actually require now charts and visual aids. So I'm not joking when I tell you that we have literally received an RFE where the only thing they asked for was a chart.
Wow.
And so, good luck to those of us that have nary the creative side, no creative gene whatsoever, because then we're like trying to make doodles and create some sort of a chart for USCIS. So it's like, there's a reason I went to law school. I had no creative gene.
So you have to use visual aids.
Yeah, yeah. Yeah, I have my younger associates and paralegals that mercifully are good with Canva and whatever. So I'm like,
Oh,
okay,
that's
knock
good.
yourself out.
That's good.
I'm not handling this piece, but it's very, very specific with in terms of what they want. And the source of funds report is very important part of your EB-5 application. So make sure that you're working with somebody that knows how to do these and is able to do them correctly, right? So that brings me to the end of at least what I had planned to talk about. But if you have any questions, more than happy to answer them.
Um, Kripa, I
Yeah.
did have a question actually. Just going back to something you said before about the source of funds. Um, so I want to ask, see, as a regional center, we accept when the immigration attorney files that source of funds, we accept it, and we also run the risk of them receiving a denial, then we would have to refund the money depending on how the documentation is written. But you as an attorney, I wanted to ask if you see that someone's source of funds is just not complete, right? It's not it has some risks in it. You disclose that to your investor, right? To your client, right? You tell them this is risky, don't do it. Is that
Well,
correct?
I send them a letter saying if you insist on going down this path, you're likely to get either a request for evidence at best or a notice of intent to deny or an outright denial.
So the investor would know. So like an
Yes,
investor that would be, worried about it would know ahead of filing that, this is risky.
yes,
Okay. So that's very important. And I think it's important for the clients to know before they make that commitment, before they, invest that money to know that, oh, okay, like it could be risky and make that decision on their own.
yes. Now, again, I'm going to say something here, and I don't mean disrespect to colleagues in the immigration bar, but not all attorneys have the experience or the ability to handle EB-5s.
Right.
EB-5s are very, very different. They are incredibly detailed. It is a combination of tax law, investment, right? It requires you to know local laws of other countries, requires you to understand how business is done in other countries. So it takes a lot of time to be able to properly create a source of funds report and to advise you on exactly what sort of documents you need based on your country of origin,
I'm
right?
actually happy you said that because I've had clients who were like, oh, but I had an immigration attorney that handled my H-1B. I'm just going to use that immigration attorney. And just because someone is an immigration attorney doesn't mean they know the ins and outs and the many variations of EB-5.
Right.
Say so. I always tell them, like, find someone that specializes in EB-5, someone that
Yeah.
has done EB-5 before. I've even had clients who said my cousin is an immigration lawyer in America. They're gonna do it. And I'm always scared when I hear those statements.
Yeah.
Creeper, maybe on that note, thank you very much. That was fantastic. Really
Thank
helpful.
you.
I learned a lot. But could you maybe just tell us a little bit about your practice? I mean, are there any areas or countries you specialize in, or any types of cases you specialize in, or if you wouldn't mind?
Yeah, sure. So for us, so again, for me, my practice includes EB-5 and foreign direct investments. I do a lot of individual investor visas, right? So both EB-5 direct and E2s. And source of funds comes into both of them actually very heavily. With respect to where majority of our clients are from, we work with significant number of clients from China and of Indian origin. So whether they're in India proper or in the MENA, a lot of clients from Dubai, Qatar, just the MENA region in general, and now increasingly quite a few clients from Nigeria. It's a very different source of funds, very different documentation requirements for each of those countries. As a firm, we have the ability to take on a little bit more because we also have quite a bit of diversity within my immigration team. So just in Seattle, we have somebody that is born and raised in Korea, and so she can handle Korean investors. We also have a Latin American practice that's based in a San Diego office, and they very, very often work with investors out of LATAM that are seeking to invest in the US, and so we have country condition expertise there. So we have a very broad-based practice in terms of where our investors come from. But yeah, we do, a lot of EB-5s, a lot of E2s. The immigration practice is, I guess, heavier in terms of our investment-based practice than we are H1s or perms.
Excellent. Thank you.
Of course.
I
Drew, I think
think
that was great.
I think it was. Thank you so much, Kripa, for being
Of
here.
course.